I'm criminal defense attorney Joseph Abrams. Today's video is the final installment in a three-part series in which I discuss the most important aspects of federal sentencing advocacy, or in other words, how to argue for a mitigated or lesser sentence. In part 1, I discussed the credibility of the defense attorney as one of several important aspects of sentencing advocacy in federal criminal cases. Last week, in part 2, I discussed the defendant's remorse and acceptance of responsibility for the offense as another of several important aspects. Today, in the final installment, I will discuss psychological evaluation reports and character letters as other important aspects of sentencing advocacy. So, how are psychological evaluation reports and character letters viewed by judges? Well, to begin with, most judges understand that mental illness is pervasive among criminal defendants, and they welcome psychological evaluation reports to better understand the defendant. However, and not surprisingly, judges will only give these reports weight if they are credible. For example, if the report indicates that mental illness prior to the offense was in fact a contributing factor to the defendant's conduct, this is likely to be viewed by the judge as important information. On the other hand, if the report merely states the opinion of a paid professional who spent maybe a couple of hours with the defendant while awaiting sentencing, this is not likely to carry much weight with the judge. There is a similar, if slightly different, dynamic at play with character letters. First, the quality of the letters is significantly more important than the quantity. A campaign to obtain as many letters as possible is usually a waste of time and of little help. Instead, the letters should inform the judge about the defendant's life and good deeds that only the writer can know and wasn't even shared by defense counsel. Also, keep in mind that inarticulate descriptions of a defendant's kindness can often resonate more powerfully than form letters that list all of the defendant's supposedly great attributes. It's also not particularly helpful for the writer of the letter to say, in effect, that they can't believe the defendant would commit such an offense. Conversely, an employer who is aware of the offense and yet commits to rehire the defendant in a character letter, that can be particularly powerful. This has been criminal defense attorney Joseph Abrams. Thank you for watching and listening. This concludes our three-part series on federal sentencing advocacy. I hope you found it helpful, and we'll see you next time.